This is a situation.
What do you contend then is the standard that we have to apply to this in order to get a recount? There are two issues here. One is whether or not you demonstrated you were entitled to a recount of those 9,000 votes. And the other issue is whether or not you would actually win the contest, which I think are two different issues. So what is the standard to apply to the first one? That is, are you entitled to a recount? And what did you demonstrate to the trial court that you contend to us demonstrates that entitlement?
We demonstrated first that there were a large number of ballots that were not counted by the punch card machines. We demonstrated second that when you have a very close election, you have to have a manual review of those ballots in order to have an accurate tally. That was not just our expert, that was their expert, Mr. Amon, who testified that you had to have a manual recount in a close election.
But why wouldn't that apply to all the other counties, at least the punch card counties, where there are undervotes, and those votes also haven't been counted? If we're looking for accuracy, which is what has been the statement from day one, then why isn't the request made, and wouldn't it be proper for any court, if they're going to order any relief, to count the undervotes in all of the counties where, at the very least, punch card systems were operating? In other words, is there something different about Dade, Broward, and Palm Beach and their use of the punch card than the 17 other counties that also use punch cards?
I think the first difference is that that's where ballots were contested. That's where first a manual recount was requested, and that's where ballots were contested. And throughout the interpretation, not only of the current version of 168, but prior versions of the contest statute, this and other courts have looked not at the entire type of ballot that may have been involved, but only those ballots that were actually contested by a party.
We've never had a